Hello and welcome to The Big Picture. The confrontation between the judiciary and the executive continues to cause serious concern. The latest outburst of the Chief Justice of India last week against the government for delaying appointments to the higher judiciary has once again soured the relationship between the two. In fact, Chief Justice of India was scathing in his observation against the government and even contemplated a contempt of court notice against the secretaries in the PMO and Department of Justice before he was assured by the Attorney General of action before the next hearing on November 11th. Meanwhile, as a response, the government cleared the appointment of 10 judges for the High Courts of Delhi and Guwahati yesterday. However, the larger issue of who should be appointing judges and how they should be appointed continues to be debated, with the revised memorandum of procedure not being finalized, as the Supreme Court Collegium and the government have been unable to come to a consensus. Why has this confrontation continued, and is it because the distrust which seems to prevail between the two pillars of the Constitution? We will discuss all this today with Justice B.A. Khan, former Chief Justice of the Jammu and Kashmir High Court, H.K.Dua, former MP and a veteran journalist, Raju Ramchandran, senior advocate of the Supreme Court, Vivek Katju, former Ambassador, and Satya Prakash, legal editor, Hindustan Times. Welcome to all of you. Justice Khan, is all this delay and the kind of remarks which are being made and the discussion and the debate between the executive and the judiciary, what is the underlying reason for this?
To me, it seems to be a struggle for power of sorts. This is not a case of mistrust or distrust, because that involves a trust being reposed and then that trust being not discharged properly. Now, here is a case of both sides, executive and judiciary. They seem to be engaged in a game of one-upmanship, some kind of a tug-of-war on what? And each wants to have a pound of flesh. And that pound of flesh is what? That is judicial appointments to the higher judiciary. Now, Girish, I fail to appreciate and understand at times that you both executive and the judiciary believe in making appointments to the higher judiciary on merit, and which can contribute to the accountability of judiciary and efficiency of the judiciary. Then where is the difference of opinion? Where is the area of difference of opinion? Now, why can't two sides amicably sit down and arrive at a common consensus on what should be the criteria on the basis of which the selection of a candidate to the higher judiciary should be made? Now, without that criteria, and I have been always urging it, please don't go ahead without that criteria. You are wanting to push in people from both sides, and that is the actual dispute.
But this has been going on forever.
No, this has not been going on forever. Earlier it was not the case. See, every time executive had a hand in making appointments, when was it not?
Sir, since '93, when the collegium system has been established,
yeah,
this has been the case.
Yeah.
Now you're saying that certain ways in which, different ways in which it has to be done. Then both the executive and the judiciary don't seem to be in agreement in what should be that the memorandum of procedure.
No,
for instance, it has not been finalized.
To me, it seems that both don't seem to be interested in having a selection on merit. If you want to have a selection on merit, why can't you have a criteria? Why can't you have a transparency? Why can't you say that we want this in a particular gentleman to be qualified for a judge? What's the problem in there? And why are you lingering on that? What is that memorandum of procedure which Supreme Court tells you to prepare and which you are not preparing for the last 10 months?
No, they have prepared, and they don't seem to be in agreement on certain issues.
No, what is to be agreed on that? Agreed on that to be what is the criteria for merit. What is the agreement? Well, this is not, negotiation is not to take place on something which is out of the world. See, you have to agree that a candidate has to have this to be qualified for it, and that has to be made public.
And you think that is where the problem lies?
That is the problem lies. Otherwise, minus that, the scope is for what? The scope is for induction on both sides of people who may not ultimately prove to be worthy of selection of a constitutional post.
Sir, but anyway, Raju, do you think that is where the problem lies? The NJEA judgment was the crucial. Was NJEA judgment the crucial turning point leading to this kind of a confrontation, or you think that this has been there before that also?
No, there's always been a certain amount of creative tension, but the NJEA judgment, you're right in saying that's the tipping point. Now, I myself am a critic of the NJEA judgment. I've spoken and written about it. But that is the law of the land. And it seems that the government has not fully reconciled to that judgment. And that is what is making it create roadblocks. But I agree with Justice Khan that both sides are to blame, though for slightly different reasons. Why do I say this? Now, when the Supreme Court delivered its NJEA judgment, it also acknowledged that there was much that was wrong with the procedures of the collegium. And after inviting suggestions, after holding detailed hearings on procedure, after the judgment was delivered, ultimately left it to the government to come out with a new memorandum of procedure. At the same time, the Supreme Court didn't clarify that until the new memorandum of procedure was put in place, the old memorandum would continue. And therefore, the government now uses this as a reason for sitting on appointments. But then, as the Chief Justice rightly asked, if this was the reason, how have you been clearing appointments piecemeal?
Right.
Either you don't clear any appointments, come back to the court and say we can't clear appointments until this new MOP is in place. They don't do that. So it gives the impression that the government is selectively appointing judges. But at the same time, the Supreme Court also has a duty to see that a proper memorandum of procedure is in place. It can't take 10 months of deadlock between the two sides for a memorandum of procedure to be in place.
Right.
And therefore, I think the court also needs to finalize this quickly. And if there's a deadlock, I think there needs to be a face-to-face meeting between all the members of the collegium and the senior members of the government so that this is thrashed out once and all across the table.
That doesn't seem to have happened in these last 10 months. Mr. Dua, the NJEA judgment was very clear. It said, the Chief Justice, or rather Justice Kehar, who was writing the judgment, said that it is difficult to hold that the wisdom of appointment of judges can be shared with the political executive. So it means that the NJEA judgment and the Supreme Court's final view at this point of time is that political executive cannot have a role in appointment of judges. Is there a different, if this MOU comes into place, can there be anything different than that?
No, I agree with Raju's suggestion that both sides should sit together and sort out. You see, the relations in a democracy between the judiciary and the executive cannot be too cozy either.
Should not be.
Should not be. Cozy relationship is dangerous. It's as every embrace, you do compromise. But basic distrust is not the appointment of judges. Basic distrust was in 70s, early 70s, when Mrs. Gandhi asked for committed judiciary, committed press, committed bureaucracy. That is the time the distrust developed. And then during emergency distrust, then supersession of judges which took place and people like Justice Khanna had to resign. And there the people became aware that where does the risk lies when the executive wants obliging judges to be appointed, convenient judges to be appointed to the Supreme Court. And executive, irrespective of the party in power, the executive is very uneasy about the basic structure of theory which Supreme Court accepted. That essential core of the Constitution cannot be amended by even by majority, cannot be amended, or whatever the requisite majority. Now, appointment of judges is related to that. They would like to have enough judges which has to interpret what is the basic structure of. It is not defined. It is not. That's it. What is the basic structure? So that tomorrow they can amend the constitution for convenience. So that's why it is not just problem between Judge A and Judge B and Judge C being appointed. Essentially, executive wants judges of their convenience, irrespective of whether it's Mr. Gandhi government or BJP government, and judiciary wants to keep its right, which it acquired in '93, that we are the.
And
So that suspicion of the executive remains in the judiciary, and executive is certainly suspect that judiciary is overstepping its limit. Now, the best way is to sit together and work out the framework on appointments of judges, and as well as you observe the limit. You have to run the government of the country. Executive has to run the government of the country, and judiciary also has to protect the constitution from the ravages which can come irresponsible exercise of executive power.
Is it a power? Okay, Mr. Katju, you come from a family of legal luminaries.
I'm not one.
You're not one. You're not one.
I've been only a diplomat.
Yes, but tell me, is this distrust which is crept in between the judiciary and the executive? Where do you see this having come from? Is it a systemic problem, or is it something related to personalities?
Look, I've often wondered how have we reached this impasse, and how have we reached this pass, this sorry pass that we are seeing today. And I wonder whether in '93 the judge's case began at all. Because Mr. Dua is absolutely right. What happened in Mrs. Gandhi's time for a committed judiciary was outrageous. And I think the judicial system and the political system had enough strength to push it back. So even though there was a desire for committed judiciary, bureaucracy, committed everything, the Indian people didn't have anything would have none of it. And the emergency failed, and we know what was it. Now, my second point is that the power of appointment has a certain element of patronage in any system. You can have it merit, as Judge Saab has said, but the fact is that the power of appointment has certain political connotations. I use the word political in its widest sense, in the use of power. Whether you have it in a university, whether you have it in the judges making, deciding who will be a judge, or whether it is the political process. The next is that whatever may be the letter of the law, of the constitution, I believe that the systems cohere, and it's been my experience as a diplomat seeing different systems, when there is a certain convention and a certain consensus on conventions, when that breaks, then whatever may be the letter of the law, it is very difficult to take that system along. Which brings me to my next point. There was a system relating to appointment of judges where there was a process of give and take between judges, the Chief Justices and the executive. And strong Chief Justices used to have their way. Permit me to read something from Justice Hidayatullah's biography. He says this relating to the time when he was Chief Justice of the Madhya Pradesh High Court, and Madhya Pradesh had just come into being. He says, in the appointment of judges, whether for the High Court or for the post of district judges, Chief Minister Shukla had his own candidate for each vacancy and for whom he would canvass the Chief Justice. But Chief Justice Hidayatullah resisted this. He goes on to say, and I'm a little embarrassed, but allow me to read this. He says, when Dr. Katju became Chief Minister, the whole thing changed.
Dr. Katju was
my grandfather. His remark to me was, I'm quoting, his remark to me was, Chief Justice, these are your courts and you know best. If I know or hear anything about a candidate recommended by you, I shall caution you. Otherwise, your choice will be my choice also. And he says this is how it worked harmoniously. And that has broken down today.
That harmony seems to have completely broken down. Satya Prakash, where is this heading towards? There's suddenly on Friday we saw the Chief Justice, outburst in the court. It's not the first time it's happening. and then on Monday we saw suddenly 10 appointments being cleared by the government. Is this kind of knee-jerk reaction going to be is what we're going to see in the coming days, or you think that there will be some kind of a consensus evolving soon?
Well, I don't see a consensus evolving very soon in near future, and this appointment that has been cleared, I suppose almost 10 appointments. It has not been a knee-jerk reaction on the part of the government. The bulk of the appointments relating to Allahabad High Court, around 35 judges, is still pending with the government. But the real issue is not about who appoints judges. The real issue is how a judge is appointed.
Absolutely.
And whether there is transparency or not. In the entire controversy, what has been the real issue has got lost. The real issue is how a judge should be appointed, whether under the NJEA system, which has been declared unconstitutional by the Supreme Court, or under the collegium system. In both, there is no guarantee that the system would be transparent. So what is needed is, even in the collegium system, the Supreme Court should ensure that there is transparency. Unfortunately, from within the collegium, there are voices pointing out the fact that there is no transparency in the functioning of the collegium system. Unless that is guaranteed, we are not going to get the desired result. And the Supreme Court, where it is lacking, is they are not coming out with a system. They could have done it in the NJEA 2 verdict, in which they said the government should be framing the MOP, Memorandum of Procedure. Instead of leaving it to the government, they should have framed the MOP, or at least basic guidelines they would have given to the government that this should be framed on these guidelines. But they didn't do it. And leaving it to the government, and now the government is trying to achieve what they could not through the NJEA. The government is saying national security would be a ground to overrule some appointment. The government is saying public interest would be would be a ground to overrule some appointments. They are trying to achieve what they could not through the NJEA. This situation has arisen because an elected government, it does have a legitimate stake in the entire system. If you don't allow them to have any say in the appointment, they would try to achieve indirectly what they could not or they cannot do directly. The system cannot work like this. There has to be some element of trust between the executive and the judiciary.
That seems to be.
If the trust is lacking,
that seems to be lacking.
Then it becomes very difficult.
There has to be give and take.
And give and take. And Prime Minister Mr. Modi had suggested in April that there should be a meeting between the top judges and some senior government functionaries, and it can be sorted out. But unfortunately, that meeting has not taken place.
Has not
Unless
taken
that
place
happens,
even now.
it's difficult.
After 7-8 months. Yes, Raju, you want to come in?
No, I agree with Satya Prakash that ultimately there has to be transparency. And when one of the judges in the collegium recently in the month of September raised his concerns about the need for transparency and the need for established procedures.
Right.
I think he said something very important, something which other judges have said after their retirement. This judge has said so during his tenure.
Right.
And this is the problem when it comes to the judiciary managing everything. They are not able to lay down proper systems, whether it's time management in courts, whether it is docket management, things which need to be given to a management expert. So similarly, when it comes to deliberation of a collegium, again there should be set procedures in the way in which other high-level appointing bodies lay down their procedures. And this is where the judiciary has fallen short.
Okay. Justice Khan, you know, I was asking earlier also, is this a systemic problem or is it a personality problem? Is clash of personalities?
No, I don't think it's a clash of personalities. See, Girish, this kind of a relationship, indifference relationship is inherent in the constitutional scheme itself. So, in a doctrine of separation of powers, we don't have that political class which Mr. Katju was talking about, which has the appreciation and realization of what should be the role of a particular limb of the state. Now, the three limbs of the state sometimes get engaged in a rivalry sort of things on the pretext of one encroaching upon the other and so on.
No, sorry to intervene. No. Is there where the problem lies? The overreach of the judiciary. The executive has been complaining for quite some time now that the judiciary has been overreaching. Is that where the problem starts?
In human nature, Girish, see, executive is that limb of the state which is vested with all power, with all trust to make policy, to execute that policy, to hold the purse, to do everything. And judiciary is a check on what executive does. And nobody likes to be checked unless you are very, very conscientious, unless you are very, very appreciative of the constitutional scheme, unless you are very, very conscious political class. That is not there. And that is why this problem arises every time. No bureaucrat takes kindly a judicial order, because that judicial order upsets his order on the basis of
upsets his scheme of things.
Similarly, no political class takes it kindly when its policy is upset by a judicial review. Now, judicial review is given by the Constitution. Once that judicial review is exercised, that is to be accepted. And we had a political class up to the time which Mr. Katju was talking, who had appreciation for this, that this is a part of the Constitution and we have to go by it. And they had all the respect for the judiciary to be a watchdog, to be a check on the executive functioning.
So you are saying that the problem lies in both the places. All of you seem to be saying that. Mr. Dua? So, the problem is not the overreach of the judiciary. The problem is not that, appreciation of what the problem. Where does the problem lie?
The problem is not clash of personalities. Problem is inbuilt in the institution. But there's suspicion.
No, but as far as inbuilt in the institution, Raju was talking of creative tensions. You also said earlier about how there should not be a cozy relationship between the two.
Executive has to assure the judiciary that we have no intention of curbing your independence by whether through MOP or through this act which was passed. We have no intentions to curb the independence. Now, that kind of faith the executive should generate in the judicial independence. Judiciary also should not be too touchy that every small little thing is a challenge to their independence. Now, this kind of tension which you are talking about, what is developing is a confrontation. What Raju rightly says, it should be creative tension. From this tension, a way out should be found. And one way is to find an agreement, use MOP. For that, you need to sit together. I can't believe that judges of the Supreme Court and wise men of the government cannot sit together and cannot evolve an
MOP
for what kind of judges should be appointed to the court. Now, that is the way to tackle the problem, not by public blame game, not by a daily battle through the media. It is there, sit together and let's work the system, which is the law of the land.
Okay, Mr. Katju, you think that it is the quality of people which you were reading from. The difference in the quality of people in the higher positions which is creating this.
No, I don't subscribe to that view. I think the people of India elect a political class, and I do believe that a political class is a responsible class, just as I believe the judicial class in India is a responsible class. Both have the good of the nation at heart. Yes. But I do believe that extreme positions are now being taken. And I'm extremely concerned.
And why do you think these extreme positions are being taken?
I think the judiciary, and here I will submit for your consideration the thought that the judiciary somehow, for the last almost 2.5 decades, has got the feeling that at the end of the day, they are the only guardians of the Republic. Now, let me read something. You read the first line of a certain paragraph from Justice K.R.'s judgment, and with great respect, I would submit this before you. The next line, what does the next sentence say? In India, the organic development of civil society has not yet sufficiently evolved. What does it say?
This was the judgment of on the NJEA case.
On the NJEA case, it fills me with dread when I read a sentence like this. Our whole basis of our constitutional and political structure, our republic, is in the sense of our people, the good sense of our people. Even if a section is illiterate, we believe that they are responsible and they will choose responsible representatives. So therefore, then to argue that the representatives who've been chosen are the next sentence. Please allow me to read, just take me a second. The expectation from the judiciary to safeguard the rights of the citizens of the country can only be assured by keeping it absolutely insulated and independent from the other organs of government. There can be creative tension, as Mr. Ramachandran says, fine, but there has to be an element of cooperation, and cooperation cannot be guaranteed by insulation.
Okay. Would you like to respond to that?
Yeah, I take a strong objection to this. See, judiciary is not under any mistaken belief that they are the only custodians of. Judiciary is the custodian of the Constitution, and Constitution gives it a power to protect the rights of the people, and those rights are to be protected against the executive action. Now, therefore, this is not a case, but at the same time, I must also say that judiciary should not be arrogating everything to itself and in the name of the independence of the judiciary. The independence of the judiciary is again a bogey which is being used a number of times for several reasons.
For right or wrong reasons.
Because independence of judiciary is there should be no interference in the functioning of the judiciary, which is not there.
Okay. Raju, would you like to respond to that? Would you like to respond to Mr. Katju's? And actually, he was only
just
quoting.
wish to make one point.
He was
Yes,
only
in
quoting
response to
from
what-
Kehar's judgment.
In fact, I myself have picked up that sentence and criticized it because I also find that unacceptable. This criticism of civil society and the view that it hasn't matured.
Evolved.
But what I wish to also point out in response to Mr. Vivek Katju is that the sense of, within inverted commas, self-importance, which is sometimes perceived as being possessed by the judiciary, I say it with all respect, is also partly due to the abdication of the political class itself
Exactly.
in situations where it ought to have asserted itself.
Absolutely.
How often the political class
Once it
finds
was
it
good.
more convenient to leave it to the courts instead of taking a decision. So that has also led to an increase in the importance of the judiciary.
Absolutely.
That wouldn't have happened.
One sentence,
Ab-
here, if I may.
Absolutely,
Just
sir.
one
If the political class had also played its legitimate role.
Right.
Yeah.
It seems to have abdicated. There is no doubt about it.
No,
Yes,
just
Mr.
one sentence.
Yes.
I entirely agree that the political class abdicated its role. But I would have very much hoped that the judiciary would have lobbed back these issues to the political class and exercised self-restraint.
Okay. Yes, Satya. Very quickly, last
Well,
word.
much of it because of the fact
I agree
that
there. I agree there.
much of
Okay.
it because of the fact that many of the judges, they are still living in the hangover of emergency. They should come out of the hangover, and they should also believe in the fact that there are other organs of the state, namely the executive. They are equally responsible, the legislature, and also the civil society and the press. So to say that judiciary alone can safeguard democracy, that's too much. They should realize that there are other organs and civil
Okay.
society also.
Okay.
They are there to help, and they should come out of this hangover of emergency.
Okay. I think on that note, we need to end. This is a discussion which will have to be continued because there doesn't seem to be a solution. But hopefully, in the coming days and weeks, hopefully the government, the executive, and the judiciary will come to a consensus, and then we will not see these kind of outbursts in public. Hopefully, in the future. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.